In the name of God, the compassionate, the merciful. Good evening, friends, and welcome to Crime and Punishment, episode 70. Guess we've been doing this for a long while now. This is the official podcast for the Invictus Law Firm, PA, a criminal defense law firm in Orlando, Florida, the website for which is augustusinvictus.com, and as me, yours truly, the host of this program. As you probably know already, this is not news to you, the world has gone mad. Good evening from the east, Brian. Frank, good evening to you. The world has gone mad. The feds have shot down 4 UFOs last time I checked in. And then I guess that was enough for the aliens to get the message, because haven't heard about any since. Instead, we've got chemicals and a train explosion in Ohio, a hazmat truck overturning in Arizona, an industrial field on fire here, just south of me. What is going on? Who knows? Who knows? Maybe it's to distract everybody from the Nord Stream pipeline situation. Maybe it's, who knows? You could make up conspiracy theories all day. Maybe one of those conspiracy theories is that we are under actual attack, that this is sabotage by a foreign nation. That would be interesting. Who knows? All I know, because this is a legal program, is that the legal news is also just as crazy. There's just, what is that line in The Second Coming by Yeats? The center cannot hold. Turning and turning in the widening gyre, the center cannot hold. There's no mooring to civilization anymore. We've talked about this a lot on this program, about the just complete abdication of common law and Anglo-American tradition, the total negation of natural law in favor of legal positivism. Like, there's no moral or legal or natural order in the universe. Let's just make things up. And whatever legislature can agree on and a president can sign, we'll call that the law. Whatever the media can whip a mob into supporting, we'll call that a law. And it will be sacrosanct. So that was mistake number one. There's actually a new book out. I didn't bring the title with me because I'm exhausted. It's the end of the week. I'm leaving town tomorrow. So it didn't even occur to me until I'm just gabbing at the mouth right now. But there's a new book out about how the Constitution is like the ultimate example of legal positivism. That we couldn't have ended up where we are. Like we had no other option but to end up where we are. That's what I'm trying to say. Because in writing the Constitution and signing it, we completely disavowed the natural law and said that we can just come together and make up law. And it will be what we, the people, say. So now you get to this juncture. We're going to talk about these crazy cases, all involving females who would never lie, I know. But it puts you in a very unenviable position to be defending the people in these cases and saying that these departures from thousands of years of legal tradition are wrong. They put you in a sticky pickle, and that's just lawfare 101, baby. For instance, who was it a few years back? Somebody in the libertarian circles just went on, I forget who it was, went on a crusade about the legal age of consent. This whole 18 years old, you got to be 18 or, under that it's statutory rape. That's crazy because, women have been having children at age 12 for like tens of thousands of years. So what is this modern construct? This libertarian pundit just went off about this. And is that the hill you want to die on? On the other hand, is what he's saying crazy? I mean, tens of thousands of years, the biological processes of men and women, are what they are. And out of the blue, a bunch of Protestant folks decided that they didn't want their young girls, their daughters, going out with these guys, and didn't want guys getting the wrong idea about their daughters, who would never do any such thing. So they make these laws about statutory rape. And look at us now. Look what a great place America has become for young women now. Now that we have statutory rape laws in place, that is. Where, actually, I just dealt with a case the other day. Dealt with is a strong word. I was consulted on a case the other day where 20-year-old guy is with a 16-year-old girl. That's illegal. On the sex offender registry for life for this. Ended up a couple years later marrying the girl, by the way. They got married, had a kid. He's still on the sex offender registry for life. People will always come back with well, what about the Romeo and Juliet defense? It's like a very specific and technical thing, like you both have to be of a certain age, and then, the older party crosses the 18-year-old threshold. Like, it's not helpful at all in a situation like that. Sex offender registry for life. The guy's treated like a pedophile who exposes himself to children on a playground because he had a girlfriend who was 4 years younger than him. So they put you in this position where if you start talking about statutory rape laws and the age of consent, you are ipso facto, a pedophile apologist. And that's what they did to this libertarian pundit whose name I can't remember for the life of me, probably because I've suppressed everything having to do with the Libertarian Party. But they villainize you for making a common sense observation like that. Like, where did this come from? Are these laws actually helping anybody? So, I'm certainly not making that case. I'm just using it as an illustration to talk about the case we're about to talk about. Heat of passion defense no longer available in slayings after infidelity disclosure, top state court says. So this is from the ABA Journal, our favorite leftist rag. ABA, of course, being the American Bar Association, which pretends to be the authority for the legal profession here in this country, but is a Marxist think tank that is trying to drive us all off a cliff. Heat of passion defense. I know you know about it. Maybe you've never heard of it in that particular language, but a heat of passion defense means you walked in on your wife banging some other dude, you kill them both. Obviously, you're still going to prison, but the law says, look, that is clearly, provoked. We're not going to hang this guy for that. Like, that's such an outrageous situation that we call it a heat of passion. This murder was in the heat of passion, so it's dropped down to a manslaughter. And this is from time immemorial. Because everybody knows you walk in on your wife banging some other dude, that will provoke you to murder. Everybody can understand that. Not anymore, of course. Now that all the moorings are cut and we're just lost in this sea of oblivion called legal positivism. Well, I don't think that's right, say the female judges in Massachusetts. I don't think it's right that women should be subjected to this. If they tell their husband or boyfriend or whatever the case may be in our degenerate society that they've been unfaithful or the child isn't really his, she should live consequence-free. If the man comes home from a hard day of work and finds his woman, wife, girlfriend, whatever, banging some other dude, and he's outraged by it, he should just swallow it like a man. Shouldn't let him off the hook by giving him a manslaughter charge instead of murder. That condones femicide. This thousands of years old legal concept we have, it's actually misogynistic, we found out. So we're going to do away with that now. Why don't we just read the article instead of me complaining about it all night? The top court in Massachusetts has ruled that a murder defendant who kills a partner after being told of infidelity can't use a heat of passion defense to lower the charge to voluntary manslaughter. The Massachusetts Supreme Judicial Court ruled against Peter Ronke in a February 14th opinion, Valentine's Day no less, that upheld his convictions on 2 murder counts for the May 2009 stabbing of his girlfriend, who was 9 months pregnant. Let's hold on here. First of all, the girlfriend was stabbed at least 15 times, leading to the death of the viable fetus. So just take this in for a second, right? This article is going to go into the fact that whatever the case may be as to the infidelity, even if we were going to say it's reasonable for you to kill your girlfriend after she discloses to you that she's cheating on you and the child isn't yours, even if we were to grant that, doesn't matter because you still killed the child, the fetus inside of her. There is no dropping it to manslaughter because of that. So this entire thing is already a massive red herring. Doesn't matter. You've already committed a double homicide. You're not getting it dropped to manslaughter. But this is a sensational case. It's a horrific case. And so, of course, we can use this to say that these psycho males shouldn't be able to kill their girlfriends just because they're, this is a family show, cheating on them. But just hold the phone here. Aren't these the same people who are saying that fetuses are not people? That women can just slaughter them at will because they're not really human? They're just a clump of cells? They're not human until they're, what, a year old? 2 years old? Like, at what point are we calling them kids now? A woman has an absolute right to murder her child, according to these people. Someone who kills a woman who is pregnant can be charged with a double homicide. Something I point out all the time. This whole, should we pass a law respecting the personhood of fetuses? We already do recognize the personhood of fetuses in every state in the country. If you murder a pregnant woman, it's a double homicide. End of story. Everybody knows that. Every sane person knows that, and no one would argue against it. But these same people who say, well, hold on, when it's a woman killing her own child, well, then it's okay, because it's not really a person. If a woman does it to her own child, it's like part of her, these ridiculous logical acrobatics they're going through. If you kill a child in the womb, you've committed a murder. So this whole thing is just this sideshow, right? It doesn't matter what the appellate court said about the disclosure of infidelity, because he's not getting it dropped down anyway. He murdered the child inside of her. That's the end of the story. But not for this machine, this Marxist machine that grinds on day and night, sleeplessly. Because now they're going to make the case that, well, this is really horrific and we shouldn't allow this to happen, so there's no more defense here. If somebody tells you that they're cheating on you, you don't have the provocation defense. Galperina, that is the girlfriend, had falsely told Ronke during an argument that he was not the father. He argued that this was enough provocation to lower his liability for the slaying to manslaughter. The court rejected that assertion in an opinion by Justice Frank M. Gaziano. The justices, quote, take this opportunity to disavow our precedent on reasonable provocation based on sudden oral revelations of infidelity and, relatedly, lack of paternity, end quote. Gaziano wrote for the court. Now, hold the phone right here. I don't know what law school is like now. It's like a different universe out there since I was in law school. But in everybody's first year of law school that I know, you learn all about the Anglo-American common law. You learn all about the 13th century case of a guy throwing an axe into a door because he's mad at somebody. You learn all about the assize in England and putting your hand on a sword and saying, if it were not the size of the time of the assize, sir, I would strike you down. And that's not an assault. It's not a battery, certainly. It's not even an assault because he's saying, I wouldn't strike you. I would strike you down if it weren't the time of the assize, but it is the time of the assize, so I'm not going to do anything. These are fundamental legal concepts, and I'm talking in a lot of legalese right now, I know, but the lawyers will understand what I'm saying. Point is, we have all of these concepts that go back literally 1,000 years. And it demonstrates to you really the concept that law is based on morality. Libertarians will often try to divide law and morality and say they're not the same thing. They very much are the same thing. Law is like a codified version of morality. So we have these defenses in criminal law. Defenses like provocation. If you are sufficiently provoked to an attack and you kill somebody, well then either you're just walking away because it was self-defense or it was completely justified homicide, or you have a lesser charge like manslaughter for which you can be convicted. So, one of those defenses is you walked in on your wife cheating on you, you murder them both, manslaughter. It's just common knowledge, right? One thing that absolutely cannot be provocation to violence or especially to murder is words. You go out over case after case after case for 1,000 years. A man's words to you are no reason for you to strike him. Everybody knows that. We've based our entire civilization on that, really, for like 1,000 years. Somebody says something mean to you, you don't get to punch them in the face. That's not legal. Somebody says something vicious to you, you don't get to strike them down with a sword. We've gone over this for 1,000 years. We've got case law on it out the wazoo. And yet, was it like 3 years ago, tops, the FedEx driver situation where he was called an N-word, got mad, hit the guy, killed him? Well, sufficient provocation. The guy used the N-word. Unbelievable. Like I said, we have severed all moorings to the past. There is no more common law. There is no more real history in the law. One of the early episodes of this program, we talked, actually several of the early episodes, we talked about the tie between the law and the soil. Boundary stones, things where law is tied to a very real foundation. It's not abstract, it's something concrete, or at least something that derives from a concrete notion. Now, law is just, it's like fractals out in the ether. It's like, well, let's just make up some words, slap it on a piece of paper, a panel of judges will sign it, and oh, voila, it's now a law in the appellate court. Or even better, we'll slap a bunch of words, a lot of more words and a lot more pages, and we'll call it a statute, and we'll pass it through the legislature, and the governor will sign it. Or better yet, a president. Now that's a law. It's just whatever you make up now. But we still do base things on morality, right? We're going to overturn 1,000 years of jurisdiction and say, actually, words are provocation enough to kill somebody if you use the N-word. If you say something racist, well, now you have your provocation. Doesn't that show the values that we have as a society? Conversely, against the values we used to have, where men don't get so, hung up by words that they kill somebody. It's not something men do. We cannot countenance that as a society, and we're not going to recognize that as a defense in the law because men are tougher than that. That's gone. It's gone. You say something racist now, well, we value as a society tolerance, and, you can kill over that. If somebody says something intolerant, well, manslaughter now, or you just walk scot-free. Likewise, in this situation, forever, everybody has understood your wife cheats on you and you walk in on it. Like that is something so enraging, so outrageous and morally bankrupt, something so perverse that any reasonable man, like we can imagine ourselves losing our minds to that point, and we understand it was obviously provoked, and we will say, look, you can't just get away with murder, but we understand the situation. We will put the charge of manslaughter on you, right? Not anymore. Our values as a society have changed so much that this is unacceptable. Besides, what does marriage really mean anymore? Marriage is just a union that has tax benefits. And if you're not a man and a woman and you can't make children, well, that's okay. You can be a man and you can adopt children and get the tax benefits for it. That's what marriage is, after all, right? It's just love with tax benefits. So what does it really matter if you walk in on your spouse and they are cheating on you? Who cares? Just get a divorce. You Philistine. Like, who gets divorced over something so stupid as infidelity? Who cares anymore? What does marriage mean? What's the value of it? Why aren't we all just sleeping around all the time? Like, who cares? That is our value as a society. So these judges say, especially the feminist judges, will say, that's not sufficient provocation at all. You should have had the composure to walk out of the room and go file for divorce. That's what a reasonable person would do. So divorced from reality, so divorced from the common values we had just a generation ago. So they have disavowed their precedent on reasonable provocation. That's what the justice on the Massachusetts Supreme Judicial Court has said. As though he's disavowing a precedent that was made 50 years ago by, some old white guys in robes. This is precedent not in Massachusetts made 60, 50 years ago. This is precedent made by all of our forefathers, our entire legal tradition over 1,000 years. And you just overturn it in Massachusetts. The disavowed precedent, quote, rests upon a shaky, misogynistic foundation and has no place in our modern jurisprudence, end quote. The Massachusetts Supreme Judicial Court said. Going forward, we will no longer recognize that an oral discovery of infidelity satisfies the objective element of something that would provoke a reasonable person to kill his or her spouse. Again, like I said in the beginning, this puts us in a very bad position. This is a horrific case. A man stabbed his girlfriend, not his wife. His girlfriend, 9 months pregnant, killed the baby and the woman. This is horrible. And we are in the position of saying, no, we're defending the guy because he should have the defense of reasonable provocation. It's an untenable, how can you argue that? Cipher. All right, so a concurring justice, Justice Elspeth B. Cipher. So the court had taken an important first step by finding that oral revelations of adultery on their own can't induce a reasonable person to kill their pregnant partner. So here's the distinction being made. This girl in this story told the guy, I'm cheating on you, this isn't even your kid, turned out to be a lie. That's tragic stupidity on her part. But what if it was true? Can we say as a society that just saying this to a man, I'm cheating on you, this isn't even your kid, is provocation enough that we can understand the homicide? I don't know. Apparently that's not what we believe as a society anymore, but here's the distinction. That statement versus, what if he walked in on this affair? What if she was pregnant and he walked in on, she's having sex with the guy whose kid it is, and then she tells him, nah, this isn't even your kid? Do we then say, okay, I completely understand somebody going ape over that? Not according to concurring Justice Elspeth B. Cipher. Cipher said she would go one step further to hold that discovery of adultery, whether from oral or personal observation, doesn't amount to adequate provocation to kill a partner. So, you're welcome. I went and looked up the concurring opinion, which we're about to read right now. I concur with the court's opinion completely. I write separately to call attention to the fact that women in the United States are more likely to be killed by homicide during pregnancy or soon after childbirth than to die from the 3 leading obstetric causes of maternal mortality, and so on and so on. This is an entire paragraph about how women are victims of violence in this country, and pregnant women especially. And again, these are the same people who say that fetuses are not human beings. So abortion on demand should be 100% legal. This schizophrenia in American law, American culture, the American public, is something they will write books about. If people can read, 100 years from now. It is important to emphasize, continues the justice, that the brutal facts of this case are not an anomaly. The disconcerting frequency of lethal violence against pregnant women warrants concomitant response from our justice system. This court's acknowledgement that oral revelations on their own cannot induce a reasonable person to kill their pregnant partner is a laudable first step. I would take it one step further and reject the principle that discovery of infidelity, whether oral or through personal observation, can amount to adequate provocation to kill a partner standing alone. And then she quotes several cases in the Commonwealth of Massachusetts. One of them is her own. She is actually quoting herself. And I didn't even want to do this episode, number one, because I am a lawyer in Massachusetts, and I shudder to think that I would ever have to appeal a criminal case up there. But also because the news here this week is just so insane. Just like the UFOs and hazmat trucks and train explosions and industrial fields on fire. Like, I have to remind myself, oh, right, we do this because it's legal marketing. It's because we're running a law firm here. I don't get any pleasure from this. Anyway, so speaking of which, let's go to the comments. Good evening from Vermont, says Observer Plays. What's up, man? Let's see. Crazy 2, the age of consent, when 16-year-olds have been considered adults in almost every country since the beginning of time. Yeah. The Virgin Mary was a teenager when she had Jesus. Juliet in Romeo and Juliet, pretty sure she was, 13? Again, it's a common sense observation no one wants to make, rather than, because they don't want to be a pedophile apologist, like I said, about the person who made the mistake of doing that. So I'm just using it as an illustration. You will never hear me making the case for that on this program. What's up, Utah Strong? MW2 Freak 7. I always think that's a profanity that I just can't figure out. But what's up, man? Nice to catch you live finally. Inspired partly by you, one more person with bar here. Are you saying you're taking the bar? You're going to law school? That would be radical. I wonder what false flag is coming next. Yeah, who knows? who knows? What do you even make of the news today? With all these things exploding and UFOs falling out of the sky, like, are we under attack? Is it a false flag? Is it distraction from some other story? Epstein files, Nord Stream pipeline? Like, I don't know. I'm just plain agnostic about it. Somebody's message is held for review, so I'm not going to get into that. Turner Diaries, we're definitely not going to discuss. I've never been banned from YouTube. I don't plan on starting tonight. Let's, you know what? We got another article here. First, let me point out this disaster. So the Tates were set up. I don't know anything about Andrew Tate. I don't talk about him because he could probably beat me up. I don't really like him, but when you're charged with human trafficking, I'm automatically distrustful of it. People charged with any crimes, I'm really distrustful of it, especially when the media is so hard after you, especially when you are pushing crazy right-wing stuff and the liberal establishment hates you. Like, I look at it, take everything with a grain of salt. In this case, they finally got a wiretap on these women who made these accusations. There are screenshots of the conversation. You can go to my Twitter, Emperor Invictus, and I've retweeted that from Censored Men. And it shows the conversation between these women who straight up laugh about setting up the Tates, pretending that they love them and roping them in this whole thing where they're talking about being actresses and they should win an Oscar and how many tears should they shed. It's crazy. So go look at that. I'm not going to waste time with it because it's not a legal case really for us. It's in Romania, right? So I don't know. I've been kind of professionally not paying attention to that case, but when you see a bombshell like that, like the alleged victims are laughing and talking about, they deserve Oscars, like, you can't not acknowledge it, right? So here's the second case of the night, or third, rather, second article, though. Also from ABA Journal, our favorite voice of the legal profession in America. Federal judge rejects Trump's quid pro quo DNA offer in suit by rape accuser. So this woman, Miss Carroll, has accused President Trump of raping her in the 1990s in a dressing room. He denies it, so she accuses him of defamation for denying a criminal allegation. Mind-blowing. Mind-blowingly devious. I'm going to accuse you of a crime, and if you defend yourself or say you didn't do it, I will then accuse you of defamation. I feel like I'm a broken record talking about the Soviet Union that we were sold as kids. All of us who grew up in the Cold War told the Soviet Union does this, the KGB did that, so on and so forth. And it's laughable looking back at childhood now and thinking, oh, those horrible Soviets, those horrible KGB officers, and how could they, accuse you of a crime and you can't defend yourself? How could they accuse you of a crime and seal the records and you can't even see it? How could they, hide the evidence? How could they imprison you without bond and, disappear you from your family? Like, all these horrible things. And when you're in this profession, I have seen, really every single thing that I ever heard of the KGB doing, I have seen it in my work. Whether it's the FBI that did it or the police or some law firm, some, big corporation. Like, we in America have it's the biggest case of projection I think I've ever seen in my life. The Soviets, the Russians, the communists, like, we do all of these things. So this woman has accused him of rape. He says, no, I did not rape you. And she accuses him of defaming her because he denied the allegation. This is the insanity we're getting into right now. A federal judge in Manhattan, New York City, has ruled against former President Donald Trump after he belatedly offered to provide a DNA sample in a suit filed by a woman who accused him of sexual assault. Insider tip, for those of you who are uninitiate, when they talk like that, they're saying it's really his lawyers they're talking about. So in, appellate opinions or court orders or news articles, they're saying President Trump belatedly offered to provide this DNA sample. What they are really saying is his lawyers belatedly offered this. It's not like President Trump is talking to the judge, right, and saying, "Judge, I'll give you my DNA sample if you give me these missing pages of this document." This is just shorthand for the process. In a February 15th opinion, U.S. District Judge Lewis A. Kaplan refused to reopen discovery. The decision followed Trump's offer to provide a DNA sample in exchange for missing pages of a forensic analysis of the dress that his accuser says she wore on the day in question. So you gotta wonder about that. This woman claims to have been raped in the 1990s and kept the dress until 2019. The decision followed the analysis, blah, blah, blah. The plaintiff, E. Jean Carroll, has accused Trump of raping her in a Bergdorf Goodman dressing room in the 1990s and of defaming her but denying that it happened. Carroll first sought a DNA sample from Trump in January 2020. So she says she was raped in the 1990s in a dressing room. Didn't seek a DNA sample until January 2020, which I'm sure was not politically motivated whatsoever. Certainly not motivated by mental illness or a desire for 15 minutes of fame or selling a book or whatever sick fetish is going on. It's clearly this really happened, right? No red flags at all in this case. Carroll's lawyer had told the court in a February 10th letter that Trump's offer was a transparent effort to manufacture a dispute that would delay the first day of Carroll's civil trial for damages and prejudice potential jurors. The reason that's significant is there's a lesser burden of proof in a civil case, right? In a criminal trial, you have to prove beyond a reasonable doubt that the defendant committed this crime. And you have to prove every single element of the crime beyond a reasonable doubt. In a civil case, it's a lesser standard. You can have a doubt, but you can even have a reasonable doubt. But if there was clear and convincing evidence that they did this, you need to render the verdict, man. Much lesser burden. People take things to civil court all the time that they know they don't have a snowball's chance in heck of proving in a criminal trial. Happens all the time. Carroll has said she kept the dress in her closet until a 2019 photo shoot for New York Magazine, which was publishing an excerpt from Carroll's book. Oh, she is writing a book. Shocking. That made the rape claim. The lab report on the dress did not detect any indicators showing the presence of semen, Kaplan said, but it did find skin cells on the sleeves of the dress, some of which came from a male. The sleeves of the dress, some of which came from a male. The report referenced an appendix that it was not included when the document was turned over in discovery. The appendix related to electropherograms generated in reaching the report's conclusions, but Trump has not explained their relevance, Kaplan said. Even if there is a DNA match, it would only show that there was some encounter between Trump and Carroll when she was wearing the dress, said the judge. Yeah. And a finding that Trump's DNA is not on the dress would not disprove the rape accusation. Yeah. So this woman keeps a dress in her closet for 30 years. There's no evidence on it, except maybe a male skin cell on her sleeves. So 30 years later, you're going to go through this lawsuit for this. It's mind-blowing. So the entire point of the judge denying this request is that it would open, inevitably lead to further reports and discovery that would almost certainly delay the trial. It would absolutely delay the trial. That's what happens when you reopen discovery. Discovery is the process whereby you subpoena things from the other side, you depose their witnesses, you go through this whole back and forth on, well, what evidence do you have? Well, here's the evidence that we have. What do you have? And you drag people's witnesses in and you question them. What are you going to say at the trial? You try to get relevant information. It's a whole process of fact-finding, right? A deposition, for those who do not know, because this is an educational program, by the way, not just me complaining all night because I'm exhausted. Deposition is when you bring someone in and you put them under oath and you say, what are you going to say at trial? And if they give you a different story at trial, well, now you have it on record. Well, didn't you say this in the deposition in February 2023? Were you lying then, or are you lying now? That's what a lot of people use them for. Quite frankly, I feel comfortable giving away this legal secret. I wish more people would do this. But the reason I win some of my cases is because I will do a deposition, not just to trip somebody up in a trial, but to prove to the prosecutor, look, this is the witness you're going on. Why are we wasting our time here? Your witness is horrible. They said X, Y, and Z. This clearly contradicts the witness statement here. It contradicts the police statement here. It contradicts the evidence. Or in the deposition, they completely deny everything that they had said before. Whatever the case may be. And prosecute, at least here in Orange County, where we give credit where credit's due, we have ethical prosecutors here in Orange County. If you show them, hey man, this is what's going on, and I'm going to depose this witness and I'll prove to you that this did not happen, they will drop the case more often than not. I mean, I've had it done several times. So I think that's the major value of a deposition. My friend Matthew, I hope you are listening to this, because when I first started this program, he was saying, you should use this crime and punishment to teach other lawyers. I'm like, yeah, other lawyers, they're too big for their own britches, right? They don't want to learn new tricks. They don't want to learn ethical practice of law or the things they could be doing. Like, for instance, apparently it's another secret that I'm more than willing to share with everybody, because I wish every criminal defense lawyer would do this. You can talk to a prosecutor before they file charges. You don't have to wait for them to file charges, screw up your client's entire life, right? Drag them over the coals on something that you know is false and be like, oh, well, we'll just deal with that when we get to trial. So many criminal defense lawyers do that. It drives me insane. They'll say, oh, well, the prosecutor's going to do what they're going to do. They're not going to listen to me. The prosecutor's going to file or not file based on what they have in the file. On the what the sheriff gave them. They're not going to listen to us. Like, just chill out. We'll see what the information says, and then we'll deal with the case. No! Absolutely not. If you know your client is innocent, you have evidence to prove that he is innocent, or you have evidence to prove that this person lied or this person is the real criminal over here, you have an ethical, absolute duty to contact the prosecutor and say, hey man, this is what we have. Don't file on this case. I've won several cases just like that. Just going to the intake attorney and saying, look man, this is what actually happened. Either the cop screwed this up or this person absolutely lied and set this person up. That's a tactic I wish more lawyers would use, because it would save a lot of lives. And not just figuratively either. I mean, we've had clients that have been either murdered or who have committed suicide. Like, this is not a game. This is real life. And lawyers, man, so many lawyers just take it like, it's just business as usual. The prosecutor will file on it if he wants to. We're just going to do this deposition so we have something on paper to take to trial if it ever gets there, because I'm going to encourage you to settle no matter what you did or didn't do. Probably shouldn't do this show when I'm already tired and upset with everything in the world. YouTube has stopped for me. Looks like we're still streaming though. Anyway, so that's basically the gist of the article here. Yep, there we go. Now YouTube's back up. So that's basically the article. I don't really feel we need to finish it. That's you get the point. Anyway, so we read about the reasonable provocation defense. We talked about the Tates and the alleged victims. Oh, here's another criminal defense tip for all of you who are in law school or who are actual lawyers who are, trying to do their jobs better. Here's another major thing that drives me nuts. So one is, depositions. You can use depositions to have a case dismissed. The other one, talking to a prosecutor before they file charges, absolutely legitimate. If you can prove that your client is innocent, like actually innocent, prosecutors are not, at least here in Orange County, they're not malicious, and they will listen to you, and they will drop the case if you can prove that your client is innocent and they have the wrong person. And here's the third one, victim. Victim is such a loaded garbage word. If you are a criminal defense attorney and you call the person in your case a victim, like you are defending a defendant, and the person accusing your client is a victim and you say they're a victim, like you might as well just tell the jury, yeah, my guy did it. Let's just please go easy on him. No, they are an alleged victim. And in certain cases where it's so outrageous that I'm like, come on, are we even looking at the same case file? Like, what are we doing here? Someone will say the word victim to me and I'll be like, no. All right, first of all, that's the alleged victim. Second of all, here's what the actual evidence says. And if you say victim in front of the jury, God help you, or in the media, like you actually say, yeah, my client and the victim, like you should be charged with malpractice, okay? They are not victims if they are lying. If this didn't happen and your client is actually innocent, then that person is a complainant at best. They're an alleged victim at best. In reality, if your client is the victim, like your client is innocent, then your client is the victim, right? So please, there's 3 pro tips for all of you criminal defense lawyers out there. All of you, even those of you who hate me and, blacklisted me from the Orange County Bar Association and I can't go to your little luncheons and all that. Like, please take these tips and be better lawyers, because you're certainly pretending to be. So thank you very much for listening, everybody. And I don't know, let's see what happens with the alien invasion. And if Independence Day doesn't come by next week, we will see you next week.